Hi, good evening. This is Rahul Reddy. Along with me is my business partner, Emily Neumann. We do bring immigration news every week on Tuesday at 5 p.m. Central Time. Today we are going to have the immigration business immigration related things. Emily, what do you have today?
So today we're going to be talking about the long processing times that we've been experiencing. There was a letter sent to USCIS from some congressional representatives asking for information on that, and we got a response back. So I'll give you kind of the update on where USCIS is in the backlog. We'll talk about driver's license renewals and issues you can face based on I-94 expiration and pending extensions or transfers. Travel while you have an application pending with USCIS, and we'll talk a little bit about priority dates and try to explain why we see such big differences from 1 month to the next. You know, some of them move forward 3 days, some of them 3 months, some don't move at all. So we'll kind of give you an update on what's happening with that, and as usual, we'll answer your questions on both Facebook and YouTube. If we can't get to your question, you can always join one of our daily conference calls. You can get the schedule for that on rnlawgroup.com. And you'll be able to dial in. We do that every day to answer your questions for free. You can always set up a consultation with any of our attorneys as well by going to rnlawgroup.com.
Don't forget to subscribe to Emily's blog, which is immigrationgirl.com. And you can also subscribe to RN Law Group News, that we do bring in any current news about the business immigration. Emily, why the processing time is so long for each application? And historically, H-1B used to be like 2 to 3 months and maybe 4 months. Now we have seen a long period of time. Now we have seen a delay in the H-4, delay in the F-1, delay in everything. Why is it taking so long time? What do you have from the data that you have from the USCIS?
Yeah, so they gave us kind of their explanation as to why we're seeing such long processing times right now, and you know, the letter to me wasn't very apologetic about it. They just said this is just the way it is, and they didn't really specify that they were trying to improve things, so this may just continue to be the new normal. One of their reasons for longer processing time is receipt increases. They're receiving more applications, although in recent months that's actually drastically decreased, so that really doesn't explain why processing times are so long. They attributed some of it to the presidential election that caused additional applications to be filed for naturalization specifically. They just don't have enough resources. Apparently they have some sort of staffing model that tells them from 1 year to the next how much hiring they need to do, and the model predicted that they needed to do a lot of hiring. They just didn't have the resources to get it done. They didn't have enough time to hire as many people and many officers as the models predicted, so that just didn't happen. They don't have a lot of extra space to place any new hires, and apparently it takes them anywhere from 1.5 years to 3 years to find a location suitable for more office space. And then they really kind of blamed it on new policies. DACA caused an increase, but then they also blamed it on the executive order on national security, new interview requirements specifically for the 485. They actually gave us some data on how much the interview requirement has impacted 485 processings. So back in 2014, officers were able to complete about 1 I-485 every hour. So that's their case completion rate. It's about 1 an hour. Now it's half that. They can complete half a case every hour. So it takes them twice as long to process a 485 now compared to what it was 4 years ago, specifically because of the interview requirement, additional security checks, and that sort of thing. So also from 2016 to 2017, the number of cases stuck in USCIS's backlog more than doubled.
Yikes.
So in 2016, they had 1 million cases. This is all types of immigration applications, but USCIS had 1 million cases sitting there in 2016 that were considered backlogged. 2017, that increased to 2.4 million.
Wow.
And
that's 150%.
Yeah.
Improvement, no, I'm sorry.
Not an improvement, an increase.
What do you call it?
Increase.
Okay, sorry.
And it stayed the same in 2018, so they made zero progress from 2017 to 2018 on eliminating that backlog. Some other data we have on that case completion rate per hour. I-129 you mentioned for H-1B processing times. Yeah, back in 2014 they were able to complete a little bit more than 1 per hour. Now it's at 0.64 per hour, so it's almost half. I mentioned 485. I-765 they were able to do a little over 4 an hour. Now it's less than 4 an hour. So that's decreased as well as far as the number of applications an officer can complete every hour. And it's really just due to additional processing requirements, additional security checks, additional fingerprinting, additional interview requirements, all the executive orders. The lack of the deference policy has caused, especially for extensions, to be adjudicated just like a new petition, so you don't save any time on those.
Emily, I've seen this kind of thing and a lot of delay in the 485 applications and other things in 1999 and early part of 2000. In fact, in 1998 and from 1996 onwards, I've seen an increase. I'm speaking of 1996. I've seen a significant increase up to 2000. Then the Bush administration came in. I mean, in Houston, for a 485 application, it was taking 4.5 years if a U.S. citizen marries a non-immigrant visa applicant here. In some places, it was taking only like 6 months. There was a lot of disparity. And the labor certification used to take 4 years in Houston, in Texas, and also in New York and some other locations. But in some locations, it used to take lesser amount of time. The Bush administration, when it came to power, they have given a deadline that they need to cut down the timings to 6, from 4.5 years, he wanted to cut down to about 1 year. He waited for 6 months. That 4.5 period never went down. It actually went from 4.5 to 4 years and 9 months. This is what Bush administration did. He said, I am firing all the district directors 6 months from now because you didn't do the job. He didn't fire them immediately. He fired them, I'm firing you 6 months from now. And because you didn't do the job that I wanted to cut down the timing. Guess what happened in those 6 months? We used to have interviews Saturday morning, Sunday morning, 7 o'clock, Sunday evening, 4 o'clock, all these interviews, and cut down in that 6 months of period. The 4 years and 9 months have come down to 6 months. He's still fired. Does this administration, just like the Bush administration had, any initiative to do that right now?
No, this administration is what's causing it.
So
yeah.
it's not the officers, it's the administration which want to delay. Unlike previously in the Bush administration wanted to cut down, but they couldn't. But they were able to based on the firings that he did. But this administration probably will fire people if they do it faster, I guess. Mm-hmm. So what you're telling is that there is no way out from here in this administration right now.
Yeah, I don't think there's any plans to try to make improvements on that. I think the best thing we can do is, for long processing times, consider filing a lawsuit for
now you're discussing the lawsuit. There are a lot of many situations where people need to get their green card faster. People need to get their H-1B. For example, extensions need to be done within 240 days. And sometimes they are doing premium processing suspension. H-4 EADs cannot work if their extension is pending. A lot of different situations where people cannot work. So what solution? You're saying lawsuit can be filed? How easy is it? How much normally lawyers charge to file a lawsuit? What are the probabilities of getting an approval with these delays? And it seems the court is the only system that we need to go. What is the cost involved? Let's say my 485 has been pending for a long time. I want to get my green card for various reasons, and they're delaying. What's the reason why you can go to court?
Well, the Administrative Procedures Act has a specific provision in it that requires government agencies to conclude a matter within a reasonable period of time. And so if you can show that the government is not acting in a reasonable manner and they're extending the processing time beyond what's reasonable, then a court can order the Immigration Service to conclude the case. That doesn't mean you're going to get an approval necessarily. They're going to actually adjudicate, meaning you could end up with an approval, you could end up with a request for evidence, you could end up with a denial, but at least they do something to finish the case, and that's what a court can order. Of course, it depends on the circumstances, how long you've been waiting. There's some congressional interpretation where they said for certain types of cases, we expect the USCIS to complete them within 180 days.
For example, what is it for H-1B though? What does the Congress think the H-1B should be adjudicated for?
30?
60,
yeah.
60 days, yeah.
Yeah, so a typical H-1B, they expected it to be, Congress wanted it to be an easy process. This was part of the AC-21 statute that was from 2000. So we're looking 18, 19 years ago. Congress said an H-1B should really only take 60 days, and certainly we're seeing processing times well beyond that. So this is something that could be considered for those cap gap people who normally would have to stop working on October 1st for long pending change of status to F1. If it's taking a year to change your status from H4 to F1 or whatever your current status is, the courts may be a way to solve that, and you might end up paying less than you would in filing fees. You know, if you're paying $1,400 for premium processing, or if you're changing status to F1 and we're telling you you've got to file a B2 bridge and then another B2 bridge, by the time you pay all those filing fees, you could have paid someone to file a lawsuit instead. So I think that that's kind of the wave of the future of immigration, because the government, the agency itself is certainly not taking any action to change anything, because that's how the Trump administration wants it. The more you can delay, the delay is basically a denial. That's what they want. So definitely that is something to consider.
Now, having been covering the topic that this administration looks to be intending to delay the application, and, we have a legal norm that says delaying is denying the justice. Now, while this delaying process is going on, Emily, there are a lot of problems that people face. For example, if any of the non-immigrant visa application, change of status, extension of status, or amendment is pending, if they want to travel, what are the difficulties people face? What are the solutions in those things? When the change of status is pending, can they travel outside the country?
Well, can you and should you, I think, are two different questions. Can you travel? You can always leave. The question is, how do you get back? So when you have a change of status application pending and you exit the country, that leaving the country automatically abandons your request to change status, because what a change of status is you're asking the government to move you from your current status to a new status without you having to leave the country. But then you go and leave the country, well, now you don't need the change of status anymore. So it will abandon your change of status. If the change of status is part of a petition, like an H-1B petition or an L-1 petition, where you've requested a change of status from an old status to H or L or O, for example, the petition itself can still be approved, just the change of status portion is what gets abandoned. That's different from an I-539. So for example, you filed a change of status to H4 or a change of status to F1, and you travel while that's pending, the whole thing gets denied. That means the only way you can come back is to apply for that visa now at the consulate instead of with USCIS, wait for the visa stamp, and then come back in. So you have to be really careful and understand what travel does to a change of status that's pending, and make sure that you're aware of those consequences and what steps need to be taken so that you can safely come back. When an extension is pending, whether you can come back while it's pending kind of depends on whether your I-94 has expired or not. If you file your extension early and your extension is pending and you're going to go out and come back in before the previous petition has expired, you technically can do that, but it does create some problems with your I-94 number that need to be cleared up. That may or may not be easy to do. But if it's after your I-94 has expired and you leave, you can't come back until you have the approval in your hand and get the visa stamped and come back. So while you're here and your extension is pending, your I-94 expired, you're allowed to stay, and if it's a work authorized like an H-1B or an L, you can continue working, but once you leave, you can't come back until you get the approval. Amendments are kind of the same. If your I-94 has not expired, you potentially can come back while the amendment is still pending, but it does create an issue with your I-94 number that has to be resolved at some point so that you get the correct I-94 number on your approval notice.
We advise from the Reddy and Neumann PC that if you have any pending application, if you have any travel plans, you need to discuss with your lawyer before you make any steps. If you have the availability of the premium processing, we would strongly recommend that you take the premium processing option before you consider anything else, because that's an easy option you can, because your adjudication most probably will be done fast. If that's not there, then of course you have to look into the alternative things. Need to discuss with your lawyer before you take any travel plans. Not just, don't assume that it's going to be approved at a certain time and make their travel plans. Discuss that with your lawyer before you make any plans. Not before you go, not before you travel, but before you make any travel plans, discuss with your lawyer. Emily, having been now this administration is not poised to do the adjudication properly, and now these people cannot travel outside the country. What if the situation is when the I-94 is expired and then extension is pending, can they get the driving license?
Yeah, it really depends on the state. There are some states, that Texas included, that will not renew your driver's license based on a pending extension if your I-94 is expired and your driver's license expires along with your I-94. So you're authorized to work, you just can't get there.
So for example, an EAD extension on the adjustment of status, it's taking approximately 5 months. Of course, when the extension of status for the EAD for adjustment of status, they're allowed to work when the extension is pending. Can they use that law and then go and get their driving license from Texas?
I'm not sure how Texas deals
No,
with
they
the
don't.
EAD renewals.
They don't approve it. In most of the states, they don't approve the driving license when the thing is pending. So you may want to plan your things way early. And for a non-immigrants, maybe you might want to consider taking an apartment or something near to workplace. I don't know, you take the Uber, because the administration does want to delay intentionally. The administration does not want you to travel or does want you to abandon the application. They don't want to give you a driving license. A lot of states are not willing to give a driving license. There are some liberal states, for example, a state of Washington, not the Washington DC, but the Washington, does give driving licenses. But a lot of states like Texas, Arizona, Georgia, Florida, they don't give until they see the approval in their hand, Emily. On the priority dates, now we have the delay of the process, we have the driving license, they're already, the non-immigrants are struggling. Now, most of the non-immigrants have already tried to apply for the green card. They don't want to go through all this process. They want to get the green card. So to get the green card, they need to file an application, either I-140 or labor certification, and they have to wait for their priority date to become current so that they can file the adjustment of status and get the green card eventually. Now, can you explain, Emily, what is a priority date?
So the priority date is the date your labor certification was filed, if your process requires a labor certification, or the date your I-140 was filed if your process does not require a labor certification. So it's basically the day you started the process, that is the day you got in line, so to speak, for your green card process.
Emily, let's go back to live questions. I have some questions for you. Okay. Now, you are updating every day, is that right, on immigrationgirl.com. Mm-hmm. What's the status of the H-1B receipt notices are? Can you tell me that all the H-1B receipt notices are done, or what are you expecting more on the receipt notices?
Yeah, I think we have another 1 to 2 weeks to be receiving receipt notices. It usually goes until mid-May. Yesterday, we did get a large batch of receipt notices specifically for the advanced degree petitions that are not premium processing. We had just received a handful prior to then, and then yesterday just a huge stack came in. I think that we're still not done with those. So if you look at the statistics of the premium processing advanced degree petitions, we've received receipts in about 64 to 66% of the cases we filed in that category. The regular processing that are also advanced degree should match those statistics, because all advanced degrees should have the same chance of selection, whether you're premium or regular. So as of right now, in one of the service centers, I think we've only received maybe 25%. In the others, around 46%. So that tells me we're probably at the halfway point of getting advanced degree receipts.
If they're filed in the regular quota.
Right.
Now here is a question that comes from Sam, that he filed in premium processing, he's in the master's quota, he hasn't got the receipt notices. What is his chances now?
Well, until today, I would have told you I kind of feel like premium processing email notifications are done. Because we hadn't gotten any in over a week, and I checked back to the last year when we did have premium processing, and it had ended about the same time. That's around, I think, April 25th is when we stopped getting email notifications. But then all of a sudden, in the middle of the night last night, we get an email notification for a premium processing advanced degree petition that we had not gotten anything until now. So we don't know exactly what's happening. Maybe that was just a straggler that got sent late. Maybe we've got more coming. Unfortunately, we just can't tell. I was kind of expecting that because of the reversal of the lottery, how they purposely wanted advanced degree people to have a higher chance of selection, that they might have closer to a 70 to 75% chance of selection this year, because last year it ended up that about 65% of ours got selected that were advanced degree. But as of right now, we're still around the 65% mark. So either we've got a few more coming or we're at the end, but it's right around the time where we're going to be done with the premium processing at this point.
Nandita has this question. Any updates on the H4 EAD, Emily?
No. I checked it yesterday. It's still pending with the OMB for review of the proposal. That normally takes 30 to 60 days. I think it's been there since February 22nd, so we're beyond 60 days now. That being said, sometimes it takes longer. I mean, if you look, you can see all of the proposals that are with OMB waiting for review. Some of them have been there for 6 months, 8 months, over a year. It just takes time. We don't know what the inner workings are that's going on with that right now, but as of now, still no proposed rule because it's still waiting with the OMB.
Divya has this question, Emily, from YouTube, is that her fingerprinting has been done for the H4 plus EAD under the new regulations. And how long it's going to take for her H4 plus EAD to be approved?
Well, I guess it depends on whether it was filed along with
the H1B.
An H1B
Yeah.
in premium
In
processing.
premium processing.
So what I can tell you is our first set of applications where we did the same thing are still pending. So people that had biometrics appointments around April 19th, they did get an update online stating that the biometrics is complete and case processing is continuing, but they're still pending. So that's been, I think, since last week. So we still don't have our first approval after biometrics. So unfortunately, we don't know how long it will take.
Sarah has this question. She has a pending 485 and EAD is yet to be issued. She has filed from F1 to H4. Can she enroll in the school? Yes, you can enroll in the school. Absolutely no problem. You can enroll in the school because your H4 is not approved. You can enroll in the school because you have the 485 pending. You can enroll in the school even because just your H4 is pending. Under all circumstances, you can enroll in school. Absolutely no problem with it.
Suhail from Facebook has a question. His EB1 I-140 is approved. 485 has been pending for over 180 days. The interview process is done. Is it safe to change employers? And if yes, is it advisable to get the Supplement J approved before you actually make the switch? So yes, you are eligible.
Is it EB1A, B, or EB1B? Okay. Outstanding researcher.
Right. So you are eligible to change employers since your 485 has been pending for over 180 days and your I-140 is approved under AC-21. The important thing to know is that the new job has to be in the same or similar occupational category as the job that you were sponsored for. So if you were sponsored for an outstanding researcher or a professor, the new job should be similar to that. So you can't completely change to a non-related type of job. So as long as you and your attorney feel comfortable that it is similar, then I don't think we've ever really seen a Supplement J rejected.
But I want to be a little bit careful when it comes to EB1 cases as compared to EB2 and EB3 cases. So in EB2 and EB3 cases, they're fairly simple, should go through, but EB1 case, either it's EB1A, B, or C, I would like to get it scrutinized by a lawyer before you take any step. Now, with regards to whether or not 485J supplement should be approved before joining, that's kind of very odd to submit a 485J supplement and then get it approved before you join. Most of the times we don't see the situation, but yes, if that's possible where you can want to apply for the 485J supplement in advance and get it approved and see once it's approved you want to join, yes, you can do that step too. That's a very defensive step if you can do that. Typically it's take about 4 to 6 months for the 485J supplement to be adjudicated.
Prabhu from Facebook has an interesting question. He was on H4 and just switched over to H1B. His son is a dependent on his spouse's H4, and he wants to know if he can move the son to be dependent on his H1 instead. Yes, you can do that. Your son either needs to go for a new visa stamping or basically file an H4 extension, but make your documentation be the supporting documents for that for your H1. So yes, that is doable. I-539 has to be filed to make it happen.
As long as the I-94 for the previous H4 is not expired, I don't see any problem in moving from one H4 dependency to the other H4 dependency.
Krishna has a question. On the H4 EAD expiring very soon on May 3rd, the extension for it was filed way back in December and still pending. Can I work after May 3rd since I've received the receipt notice? Unfortunately, no. The H4 EAD does not allow you to continue working based on a pending renewal. So if your new EAD card does not arrive by May 3rd, you have to stop working. There's no way around that, unfortunately. You can try to request an expedite from USCIS, which they are rarely expediting these days because everyone is requesting expedites. You can try to seek congressional assistance to see if they can get it approved faster, but it will take longer than May 3rd for that to happen, very likely, and a lawsuit would also take likely longer than May 3rd. So unfortunately, I don't think there's a lot of choices there.
Arjun has this question that his H-1B6 year limit is expiring in February 2020. His company is now processing the EB2 process and has already filed the prevailing wage request. What are the probabilities that he's going to get an I-140 approval before February of 2020? February of 2020 is about 9 months. So if the prevailing wage has been filed right now, it's taking 4 months approximately right now to get the prevailing wage. Normally company chooses, they have 2 options. They can go ahead with the advertisement process while the prevailing wage is pending, or they can wait until the prevailing wage is approved and the prevailing wage has been provided. Under your circumstances, I would strongly recommend that your company proceeds with going with the advertisement even before the prevailing wage has been issued, because you may not have enough time to get the I-140 approved. There are also other options that you may want to consider extending your February 2020 deadline, maybe by spending some extra days outside the country that will be deducted in your 6 years. You may want to consult with a lawyer to strategize the planning. The first step that I would like to do is that get your employer to go ahead with the process of advertisement without getting the prevailing wage, because in that way you're going to cut down some of the timing that you have to file the labor certification application. Even after the advertisement, it will take approximately around 70 to 90 days to file the application. So in the meantime, your prevailing wage will come in. That's the first step that I would do. And then second, and if necessary, the step is to step outside the country for a period of 1 month or 2 months to gain any of the periods that you need to get to this, to get the I-140 approved before you hit the 6 year.
Excuse me. Awaruku, I'm sorry if I messed up your name there, has a question on Facebook. Interesting situation. H-1B was selected in the lottery, also has an I-131 pending. Can I travel? So there's going to be two issues that travel is going to cause at this stage. Number one, if the H-1B requested a change of status, as I mentioned earlier, the change of status will be automatically abandoned when you leave the country while it's pending. On top of that, USCIS has a newer policy of denying the I-131 application. I'm assuming it's for an advanced parole. If you travel before the advanced parole is approved. So when you leave, you're going to abandon your change of status for the H-1, get your I-131 denied. Now I don't know how you're going to come back because I don't know what your prior status was, if you still have your previous status, if you're eligible to come back in that previous status, or if you're going to have to wait for the H-1 to be approved, get the H-1 visa stamped, and then come back in. So probably not the best time to travel given that circumstance.
Karthik has this question, whether or not he should be hopeful that the per country limit will be taken off. What he meant to say is that the HR bill that is there where the per country limit is taken off, if the per country limit is taken off, which will be good news for a lot of people who have been waiting for a long period of time to get the green card, the priority dates might move to almost to 2015 to 2016 if the per country quota has been removed. As an AILA member, American Immigration Lawyers Association member, we've been fighting for this one since the time the priority date has been established. The priority dates came into picture in 1996. That's when I got my green card. I got my green card in May of 1996, and in June of 1996, the priority dates started coming and kicking in for AB2 and AB3. That's approximately around 24 years ago. Since then, we have been trying to fight for the per country limit. In 2003, we were able to take the per country limit off to an extent where the wastage of the green cards were being given to the people who have been using more, which is mostly Indian and Chinese national. That came in 2003. But it's not a total removal of the per country limit, it's a very semi-removal. That system worked from 2003 to 2005, but in 2005 it started backlogging again. So in 2005 to right now, it's still the fight is going on. We've been fighting this from 1996 to right now. We've been fighting on that. It's 23 years. We have little progress on that. I would recommend that you keep fighting. Try to go to Immigration Girl blog. There are draft letters that have been provided where you can send it to your congressman with regards to requesting them to take the per country limit off. But I, being an immigrant, having gone through the process though, I would advise that you make an alternative plan. Don't completely rely on this per country limit because it may not occur based on how the things are going on. If, as an immigrant, I would suggest you to have an alternative. What is the alternative plan? Maybe you may want to consider getting a green card from Canada, or maybe when you want to consider buying a home here or back in your home country, you may consider that very seriously, that you may not get the green card. I don't want you to put your 100% efforts that, okay, you're going to get the green card here, put all your life here, and then later on turn out that it may not be achievable. At this point of time, I would say that it's less than 25% chance that the per country quota will be removed at least in the next 3 to 4 years. So I definitely want you to make alternative plans in your investments, in your family planning, maybe alternative countries to think about.
So Rob from Facebook is on H4 and driver's license is expiring when the I-94 expires. Wants to know if you can apply for the new driver's license based on the new approval date on the I-539 in California. So I assume that means you got your I-539 approved, which gives you a new approval end date on your new I-94. Yes, once you have that approval notice, you can go and request the new driver's license based on that. Hopefully I understood your question correctly, but with that new I-94, you can get the driver's license renewed. Akash also has a question. Does an H-1B amendment affect an already approved H-4 EAD? No. So the H-4 EAD remains valid until it expires, and you can continue using it as long as your spouse is continuing to maintain H-1B status. So even if an application is filed after for an amendment, for example, and maybe that amendment gets approved for a shorter validity period, which we're seeing happening, as long as they file an extension after that so that the spouse is continuing to maintain H-1 status, the H-4 EAD remains valid.
A follow-up question on the priority date is that the priority date for Srinivas from YouTube is May of 2010. And his daughter is turning 21. What should be the options that he should take? I don't want you to rely on the priority date becoming current for you. Even though it's a very short period that you have, I don't want you to rely. If your daughter is turning into 21, you need to take the alternative steps way ahead of time. I would recommend that you should file F1 application if she's eligible for F1, and most probably. There are situations where we are recommending people to file as soon as they join the university, because sometimes it's taking 18 months to get the F1 approved. And the problem with the F1 is that you have to maintain the legal status until the F1 is approved. In your case, since your daughter is going to turn 21, she loses the H4 status the day she turns 21. So there is an interim application called B2 or B1 application, where you may have to file that application to keep her status alive. The alternative method is that you have to send her to the home country or to the consulate to apply for the F1. There are some pluses and minuses to do the change of status application, and also to file to send her outside the country. So you may want to discuss with your lawyer, but at this point of time, even though your priority date is just 1 year, since your daughter is turning 21, I want you to make alternative plans for your daughter. Now, let me tell you one other thing. Even if your daughter is an F1 visa, if she is under 21 and she meets the requirement under the Child Protective Act, you can file the adjustment of status even though she is an F1 visa. Just because she has converted into F1 visa doesn't mean that if your priority date becomes current, she cannot file the adjustment of status. So please make the alternative plans. I think so you're already late. I think so he's already very late, but he should make the alternative plans.
Sandeep has a question. Currently has an H1 that's valid until August 2019 and previously filed an amendment plus extension that just got denied. Wants to know whether it can be refiled as an extension or it needs to be an amendment plus extension again. Really depends on whether the terms and conditions of the original approval are still in place. And will you be continuing under those terms and conditions, or are you going to be working under the new terms and conditions that were the purpose of filing the previous amendment? So if you are now going to start working again under the new terms and conditions of employment, it has to be filed as an amendment plus extension, because you need to amend your current period to get you from now till August and then extend beyond August. If you're going back to the terms and conditions of the original approval and are going to stay with those, then just an extension can be filed anytime between now and August.
Z Xing has this question. Is employment-based green card application, is the consular processing or the adjustment of status, which is better, as the adjustment of status is taking a long time? Well, consular processing is not taking any lesser period of time just because the adjustment of status is taking a longer period of time. Also, the adjustment of status has an interim relief. For example, if you file an adjustment of status, you're eligible to file an employment authorization document, which they're issuing in about 4 to 6 months' time. If you apply for the consular processing, that relief is not there. 99% of the time, when we advise the clients, they end up choosing the adjustment of status instead of consular processing. The only time we normally go for the consular processing is where the person is not in this country and cannot come into this country. That's the only time. And there might be some rare exceptions, because consular processing takes a long time. It doesn't take any short period of time, and there are a lot of buts and ifs in the consular processing as compared to the adjustment of status. Under normal circumstances, adjustment of status is better for you rather than consular processing, unless you're not in the country.
Let's see here. I lost the question. So somebody had asked about some policy that H-1B visa holders can't switch jobs as easily anymore. I assume that's some article. So I Googled it and did find the article you were referring to. And nothing has changed, and nothing is planned to be changed on allowing H-1B holders to file H-1 transfers and use the portability provisions. I think what this article is getting at is the high rate of RFE, the higher rate of denial.
I got the same question. I thought,
no. I think they're kind of blowing things out of proportion here.
Yes. I didn't want to address this because that looks like,
yeah.
If you file an extension or transfer, you still have the AC-21 provision. It's a law passed by the Congress. It cannot just be rescinded by the administration without going to Congress. So that AC-21 provision is from the Congress.
Shan has a question. In H-1B right now, can I switch to J-2 and then change back to H-1B once my spouse gets the J-1 waiver approved? Do I need to go through the lottery process again? So once you've had an H-1B that's counted in the cap, if you haven't used up all of your 6-year limit, you can recapture that time at any point in the future. So yes, you could, assuming the waiver is approved, you can convert back to H-1B at any time in the future by filing a change of status, not subject to the cap. You don't have to go through the lottery again.
Rohit has this question, Emily. You need to answer the question here. And this question will pop up every day. If you're an immigrant and they're, when is the last day where you can say that no more receipt notices are coming of the H-1B?
So I looked back over the last several years, and I will say that usually by mid-May, we stop getting receipt notices. Now, there's no exact date there. It's dependent on when USCIS gives the announcement that they've completed data entry. Once that happens, we usually don't get very many more after that. We'll get them within a week. So I would say, generally speaking, mid-May is when we get all of our receipt notices. And since premium processing is set to begin on May 20th, I'd say for sure we should get all premium receipts by May 20th at the latest.
Sai Manoj has the question of the day. I would say that he filed the H-1B in the quota, but he didn't file for the H-4. Is it necessary to file along with the H-1B? Can he file the H-1B after it's selected in the lottery? He also asked a question, can he file the H-4 after it's approved? You don't have to file the H-4 when you're filing in the quota. You can file it after it's been selected in the lottery. Now, with regards to your question, can you wait until the H1 is approved? Not necessarily. It's because if the H1B is approved on after October, your spouse will be in trouble, Sai. Because what happens is that the day you change to the H1B, she is not legal from that day, and she cannot apply the H4 because she's not maintaining the legal status. Now, technically speaking of, H4 need to be filed before October 1st. The H4 receipt notice has to be there before October 1st. As long as that's achieved, she will be in a good shape. But if you're planning to file until the H1 is approved and it's going to be after October 1st, she will be in trouble. Before October 1st, you need to file it.
Jitendra has a good question. How safe is it to travel if you have an approved petition and all of the required documents like a client letter, contracts, and all of that sort of thing? So if you're in a third-party placement situation, it is not safe to travel even if you have all the documents. And the reason for that is the consular officers have a fraud detection unit that is going to review all of those documents. They will take your client letter and they will send it back to the person who wrote it and ask them to verify that they wrote the letter and ask whether any modifications have been made. That process takes several weeks, if not months. So just because you have all of the required documents doesn't mean it's a quick process, doesn't mean you'll get the visa right away. You can expect a 221G very likely. Just because there is fraud out there, they assume everything is fraud, and so everyone has to go through these fraud checks.
I have this question, easy question to answer. My green card has been misplaced. What do I need to do? There is an online application called I-90. You can file an application. It's fairly simple. You can do it by yourself. I necessarily don't recommend. If that's the only reason why you're filing it, I don't necessarily, I want you to file the duplicate green card immediately. Make sure you file it immediately because you don't want the green card to be used by somebody else and you get into trouble for that. So you can file it. It's called I-90. You can file the application online, pay the money fees online. You can do that.
Sandeep Reddy has a question. Can we get the H4 EAD approved even if the I-140 is withdrawn by the previous employer? It depends. As long as that I-140 was approved for at least 180 days before it got withdrawn, then yes, you can continue to use that same I-140 approval that's been withdrawn to get H1 extensions beyond the 6-year limit to retain the priority date and to get H4 EADs and renewals. Interesting question.
Andrews has this question. Can I get a green card? I'm blocked by Trump or Twitter. In fact, the green card backlog has nothing to do with the Trump administration. It has something to do with the Congress, which is not acting. I'm not a big fan of Trump administration, but the green card backlog has nothing to do with the Trump administration.
Raj has a question. He's got an H1 that was filed in the lottery in premium processing for the master's cap and hasn't heard anything yet. Does that mean I haven't been selected? I think it's still a little too early to assume that. As I said, just last night we received an email notification for a master's cap premium processed petition. So I was expecting that maybe we were done, but then I still got a receipt. So I'd say that we still might have another week or two to get receipt notices. We're probably at the tail end of the email notifications, but until there has not been any announcement by USCIS that data entry is complete, they don't give a separate announcement for premium processing for that. It just happens all at once and probably is going to be sometime next week or maybe the week after.
Josh has this question, Emily. He's a gay, and if he marries, another guy, will he get the green card? The answer is yes. The Supreme Court has given a decision on that thing. There should not be any discrimination based on your sexual preferences, so you should be fine in getting the green card if the marriage is genuine and everything.
Yeah, no issues for that at all. No separate process.
Until the Supreme Court gave a decision, there were some issues, but after the Supreme Court gave a decision in 2015 or 2014, there hasn't been any problem for gay or lesbian marriages.
Question on Facebook. H1 is valid until 2020, but due to a project change, I need to file an amendment. Can I file an amendment plus extension even though it's more than 180 days from the expiration? Yes, you can. So you can't file an amendment more than you can't file an extension more than 180 days early, but you can file an amendment at any time, and the amendment can be combined with an extension even if it's more than 180 days in advance.
Sri has this question. Can he file a green card under EB2? He got the master's degree from a university which is closed. If your university is accredited at the time when you graduated, there is no issue even if your university is closed afterwards. Absolutely not a problem. It should have been accredited at the time when you graduated. That's the point. After that, if it's closed, it does not matter. You can still apply for EB2. You can use that master's degree for getting the EB2.
Surjit has a question. He's got the perm approved, getting ready to file the I-140, but his I-94 has expired. Now, I assume he's filed some sort of extension, so he's not unlawfully present. But can I still file for the I-140 even though my I-94 is expired? Absolutely. There's actually no requirement for you to document maintenance of status in the I-140 petition. We don't even submit any proof of status. It's not required. All you have to do is prove that you meet the requirements of the labor certification and that your employer has the ability to pay. So status is not a question in an I-140 petition, so no issues there.
Kamal has this question. His I-94 is expired. Can he work beyond the 240 days after the I-94 expired? He put the question, Kamal has put the question 280 days. It's actually 240 days, not 280 days. If the I-94 has expired and your company has filed an H-1B extension, you can work up to 240 days. Is there a grace period after that? To your question, Kamal, no. There is no grace period if you just filed an extension. It's only 240 days. You need to stop working after 240 days. You can stay in this country, but you cannot work. There are certain exceptions available. You could file one more extension to do away with the 240-day rule, but I would recommend that you contact your lawyer before you take that step. But at this point of time, if it's 240 days, you need to stop working. You can legally stay in this country. Absolutely, that's not a problem.
Nikunj filed a petition in the lottery and the employer's not sharing any information about it. He wants to know if there's any other way to find out if he's been selected. So he's on the OPT STEM extension. So if you're selected and that information has been updated in the SEVIS system, it doesn't happen all at once. It's very random when it does happen. But if you ask your DSO for a new I-20, you might be able to see your receipt number on the new I-20. That's probably the best way for you to find out whether you're selected or not if the employer's not sharing that information with you. Also on the lottery, Rahul wants to know his H-1 was selected in regular processing. Can I convert it to premium? So if you've requested a change of status in your petition, you can upgrade to premium processing. When I say you, I mean your employer or their attorney can upgrade to premium processing starting on May 20th, not before. If you did not request a change of status and it's consular processing, sometime in June we should expect an announcement from USCIS letting us know when we can upgrade those. My guess would be after June 4th, because that's when they're going to get through the big mass of premium processing that are already there. But that's just a guess. So sometime in June you may be able to upgrade if you're consular processed.
Hema has this question that her H4 EAD extension is pending. Can she continue working after the EAD expires? The answer to Hema, unfortunately, is no. You cannot continue working on the H4 EAD when the H4 EAD is pending.
I'll give this question to you. This is about a 485. So Anam has a 485 pending, and this is EB2, received the pink letter asking about the medical exam. Does that mean that his interview might be coming soon?
I have noticed that when the pink letter comes in, they give an option that either you can submit the medical report immediately or you can submit it along with the interview though. But I want to look into just with the pink color if that is the statement that they have given. A lot of times we are filing adjustment of status without medical MLE. The reason is that it's taking 18 months to 24 months to get the interview, and the medicals are only valid for 12 months. So you practically have to do the medical again. So the USCIS, instead of issuing an RFE, they're issuing a pink note. Hey, you didn't submit the medicals, so you may submit it right now or you may bring it to you along when you come for the interview. That's what I'm assuming when she meant by pink sheet.
All right. Parrish wants to know which date on the I-797 approval notice is the important one. So lately, USCIS issues approval notices with a petition validity date at the top, and then on the I-94, there's a different end date that's 10 days later. So your petition and your status actually expire based on the date on the top. The I-94 end date gives you an extra 10-day grace period, but that's not status. And the reason for that is because it's not, if you're on H-1B status, it's not supported by an LCA because your LCA would have expired 10 days before that. So when you're looking at what is your actual end date, it's the earlier end date, not the later 10-day end date. That's just a grace period to give you time to exit.
Arunan has this question. His company does not disclose the perm approval and it's been 5 months. What's the interval between the labor approval and the I-140 application? The maximum days that the company can take to file an I-140 is 180 days. Not 181 days, it's 180 days. If they file it after 180 days, it will be denied. Now, once the I-140 has been applied, what I would recommend is that you can file a freedom of information. You can Google it on USCIS, FOIA. You can file an application online. You will get an I-140 petition along with your labor certification. We are recommending people when the employers are not giving the labor an I-140, you can do so by filing an FOIA. We represent sometimes the companies, they don't want to disclose their financial documentation, certain other information. So that's an easy way. And it's taking approximately 30 days to 60 days to get the I-140 petition, which has your labor certification approval in there.
All right, I think we're about out of time for today. If we didn't get to your question, please know that you can join one of our daily conference calls by going to rnlawgroup.com to get the schedule and the dial-in information for that. You can always set up a consultation with any of our attorneys by going to rnlawgroup.com, and you can continue to follow us here on Facebook, watch our YouTube videos. We're on Twitter. Our handle is @rnlawgroup. You can interact with me on Twitter as well by going to @immigrationgirl. You can subscribe to our newsletter at RN Law Group or at